welcome to our program called Navigating the Upcoming H-1B Season. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group, and I'm lucky enough to have with me today Lutka Zimocek, who is also a managing attorney, and Snehal Batra, who is managing our Raritan, New Jersey office. And we are here to give you as much information and updates as we can about the, what's happening in the H-1B arena. So thank you very much, number one, for joining. We are in very exciting times because the tides, of course, are changing a little bit. And those of you who are keeping abreast of what's happening in the immigration law arena, you're probably hearing that things are changing. The tide is turning. However, it's one of the things that we will all probably be referencing is the fact that this is not going to happen overnight. There is still a lot to be done. A lot of change is going to be, a lot of change still needs to be made. What I'd like to do is go through, I think what we'll do is we'll go right into our slide presentation. But I'd like to first mention to you, that the NPZ Law Group is a general immigration law firm. We provide full service immigration law services, business immigration law, family immigration law, asylum, removal defense, DACA, and so on. So this is our bailiwick. This is what we do. Please feel free to reach out for any one of us. We're relatively easy to find on the web, and you can also just pick up the phone and call us and speak to our staff. And if you would like to arrange a personal meeting or personal initial consultation, you're welcome to do so. We're more than happy to assist you in any way that we can. I think what we'll do is we'll go to the first slide, Lutka. Is that okay?
Before that, I just want to mention we are going to be taking questions as we go. So feel free to write any questions you have in the chat. And if we cannot do it during the presentation, we'll do it at the end, because I think that's the most valuable. So feel free to ask questions. If it's too personal, try to generalize it. And, we'll try to answer as best as we can.
Okay. And Snehal, do you want to add anything in there?
No, I think we're good.
Good. We'll jump to the first slide then. So for those of you who have actually been to some of our programs, you probably maybe recognize this slide. And I was told by Lutka that I'm not allowed to spend too much time on this slide because we have other slides that are a lot more important. But this slide is near and dear to me because what it does is it helps you understand the very basics of immigration law and how the process works in the United States. So it's sort of like a snapshot of the US immigration law system. And one of the things that I've noticed, I've actually been partaking of many webinars dealing with H-1B over the last several weeks. And I've noticed that a lot of them are geared toward technicalities. And what I've tried to do, I think what we all tried to do today is to try to boil this down to very basics for everyone so that you have some good, very basic takeaways. But again, this slide is a snapshot of the US immigration law system. And what it is US immigration law is really a spectrum that runs from the left side of the slide to the right side of the slide. And you basically have individuals in the United States who have no status whatsoever. And for those of you who are keeping your finger on the pulse, you know that President Biden is looking potentially at offering legalization opportunities for folks who are in the United States who don't have status. So we will, of course, do everything that we can to apprise you of any new developments in that area. But what I think is most important is that there's not a takeaway here that people who don't have status don't have options. They do have options. They just need to inquire about what those options are. So some of those we've listed there on the left-hand side of the slide. And then we have what are called non-immigrants. Now, non-immigrants are really interesting because non-immigrants are individuals who intend to depart from the United States. That's what we refer to as pure non-immigrant intent. But then we also have a couple of non-immigrant classifications where you have what's called dual intent. And there's a really tremendous value of having a dual intent classification because you can intend to stay and intend to leave at the same time. And there's a lot of flexibility and a lot of power to having one of those dual intent visas. So H's and O's and L's, we really like those because those are dual intent. So we're always urging our clients to consider trying to get themselves that classification.
And they not always listen to us.
And they, right, and we're going to get into that.
We'll give you some examples.
Exactly.
What could happen, the horror stories.
Exactly. And then moving across from non-immigrant to immigrant, then you have individuals whose intent, an immigrant, is a person who intends to stay permanently and live in the United States, and that's an immigrant visa. So that is, so that is another classification. That classification is synonymous with lawful permanent residence, okay, or green card status. And you can get it either through employment-based, which is the EB1 through EB5 that you see there, or through family-based process. After you're an immigrant, okay, for 5 years generally, or 3 years if you're married to a US citizen, you can then apply for naturalization. So really what this is this slide is a life cycle of what the immigration process is like. And what it does is it explains to you what the natural steps in the process are. So with that being said, now that everyone probably knows more than President Trump ever knew about the immigration process, we'll move on to the next slide. Good. So Lutka, why did we put up this slide?
Yeah, we want to explain the typical path. And, I like to give examples. And I think yesterday I was giving you one example of one of my clients, and I would like to share it just for our audience to understand, what's the typical path. So typical path is typically going to H-1B or O1, some type of work visa status, and then going to the green card. However, I'm sure we're going to get questions. I'm an F1 student or J1 exchange visitor, and I would like to proceed with the green card. So go straight into employment-based permanent residence category. It is possible, but it's definitely not the best idea. As David explained, it's much better to go first to a dual intent visa status. As I explained my example from yesterday, I have a new client who has extremely great credentials. So he would have qualified for anything. But for some reason, they decided, it was lawyer and him decided to pursue directly from F1, the green card. And they filed, I believe, national interest waiver with adjustment of status that was denied 3 times. So now he's in a big predicament, and, we are going to try to solve it. But, if he would have been in H-1B status or O1, for which he definitely qualified, and the green card application would be denied, he would be now in H-1B status, not stressed out, and we could refile the green card application. So it's very, very important to understand that concept, that it's, if you can, of course there are exceptions, but if you can, try to go to H-1B, L1 or O1 before you proceed with the green card. But this is definitely, I would say, for majority of the people, typical path to a green card.
So Snehal, I don't know about you, but my phone is ringing off the hook, and I'm getting calls from students who are saying, well, I hear that there's this thing called the H-1B lottery and it's coming up. How do I talk to my employer about that? Do you have any tips that we can give to folks who are thinking about going into the H-1B lottery?
Absolutely. So one of the things that I always suggest is, no matter whether you started, recently with the employer, you should approach them, because, the H-1B is a lottery. So if you want to try to get the visa, you need to be in the lottery, and you really don't want to wait until, the end of your OPT, whether that be year 2, year 3. You want to approach them as soon as possible. So generally we say around the holidays, connect with your HR let them know that you obviously are on this OPT, which will, which ends, there is an end date for that work authorization, and that if they wish to continue to hire you, they have to go into the lottery. So perhaps maybe in lieu of some type of end of year bonus, they can, go into the H-1B lottery for you. So that's one option. And the other one is that, just keep the dialogue open. Don't wait until the last minute, because what in our experience, a lot of employers, they might be doing this for the first time. They're not familiar with the process, okay, how it works, what is the registration, what are the employer obligations. So you want to be sure that you approach them so that there's enough time to explain this to them, they're on board, and then we can go into the registration.
And
So
I see, I'm sorry, David, I see we have some HRs, on this webinar. So the same goes for the companies. I just want to mention that,
Yep.
that, those that are unfamiliar, it's very important to start the process early on because of the lottery. So even though, your employee may have STEM OPT that allows him to work for 3 years, it's really important to start with the H-1B registration early on, maybe even the first year, because they may not make it the first time, second time, or even third time in the lottery. So, for the HRs that we have here, it's important to check your records, who, is qualified, or who you think would, should do the H-1B, and start process now. Now is definitely the time to prepare, which H-1B registrations you want to do for which employees.
So when I talk to HR or I talk to the students, if I'm talking to the employers, usually their eyes glaze over when they hear H-1B. So I think it's really important for us to just explain the basics of H-1B to everyone who's on the webinar, how it works, how does a normal H-1B analysis roll out? What are the things that we need to consider? And I think I'm going to ask that question to both of you. I'll let you sort of bandy it about, but at the same time, I'll let you know that what we do, and I often do, is I say, listen, I have a white paper that I've created here in our office, which sort of boils down to English what the H-1B is and a checklist of documents for the employer and for the employee. Let me send it to you. You digest that information, and then let's set up a conference call and let's discuss what the nuances are that apply to your particular case. But let's just do a sort of a top-down analysis for what is an H-1B.
So H-1B is for professional level workers, meaning that the position itself must require at least a bachelor's degree. And, we get these questions quite often. My uncle has a gas station. They offered me a job as a assistant or a cashier. Can I get H-1B? So it's important to understand that if individual has the bachelor's degree, that's great, but it may not be sufficient. The position itself must require a bachelor's degree in some type of specialty, because it is, for specialty occupation. We could also utilize the experience. We can also utilize the foreign degrees, and many people forget about it. So, we may have individuals that already have degrees, even though they are pursuing degrees in the US, but they may have bachelor's degree from, let's say, India. So then important thing is to do credentials evaluation of a degree to see if it is US equivalent to a bachelor's degree. That's number one. And we also have 3-for-1 rule, where we can use the 3 years of work experience for 1 year of academic. So I haven't done it too much, but I think maybe once in 15 years, but I had an individual who did not have any degree, but had a lot of experience, and we were able to get credentials evaluation based on experience that stated that the person has equivalent to a US bachelor's degree. So let's not forget about the foreign degrees. Let's not forget about the experience. And obviously it's the easiest if the individual has a US bachelor's degree, master's degree, or higher degree.
And I just want to add something to that, is that it could be a combination of things. So let's say you never completed your degree back home, you completed maybe a 2-year or a 3-year program, but you never completed it. But then you came to the US, finished your education, or you have work experience. So working with a academic evaluator, they can do that. They can look at all of your transcripts, detailed experience letters, most especially if they're progressive experience letters, to determine whether or not you have the equivalent of a US degree. So, you might be in the US pursuing a master's you haven't completed yet. It doesn't mean that, you can't go into the lottery. So it's really important to work with, immigration attorneys to evaluate your education and work experience, because you may already qualify.
And actually, Snehal, we're not really the ones who do the evaluation, right? We work with evaluators who are skilled in what they do, because they have certain guidelines and parameters that they're required to, when they do an evaluation of, let's say, a person's educational background, they have to abide by, certain parameters. So there are some that are very, very skilled in just doing academic credentials evaluations, right? There are some who do combinations, and there are some who just do pure experiential. And basically, they charge for their services the same way lawyers charge for their services. Theirs are usually like fixed fees to do these evaluations. And if you don't know of someone who can do that evaluation for you, just reach out for us, and we'll be more than happy to provide you with some reliable organizations that would be able to assist. Okay. Great. So, Lutka, tell us, what are some examples of specialty occupations? And obviously, putting up this slide, are these all of them, or is this just are we just tipping the iceberg?
Yeah, these are just examples. Those are easy examples. Chemists, lawyers, teachers, that's no brainer. Then obviously it could be any position. It could be any type of position where Department of Labor requires bachelor's degree, normally requires a bachelor's degree in specific field. Or it could be that the company, I just actually had a call with one of my clients who explained to me, well, I said, well, it doesn't seem like this is a specialty occupation, but they explained to me because of the complexity of the job, they always, for the past 10 years, required a bachelor's degree. So, number one, we look at the Department of Labor, what is normally required? Is the bachelor's degree normally required for the position? But then we can take it a step further. What does the company or what does the industry normally require for this type of position? I think that's the most important. So this is not exhaustive list. These are just specific, very easy examples, but then you have those, where they are not black or white, they're gray, and we have to do some research analysis to see if it's going to work.
So I'm really like old school, Lutka. Like somebody, I'm an old guy. So what happens is when people call me up, they go, how do I determine whether it's a professional position? So back in the day, what I would do is I would say, you go to the Dictionary of Occupational Titles, which is the Bible that is put out by the Department of Labor, as you rightfully point out. And I'd say, take a look at what's called the SVP code. And the SVP code stands for Specific Vocational Preparation Code. The US Department of Labor, for every single job that exists in the United States, has an SVP code. If the SVP code is over 7, then it's considered to be professional, right? If it's under 7, it's not considered to be a professional position. But that's not the only thing you look at. Okay, I think that Lutka mentioned, obviously, looking at the functions in the organization, right? Is it complex? But Snehal, what other things can we look at to determine whether or not an individual's position is professional or not?
Well, under the definition of specialty occupation, which is actually one major issue that's been frequently challenged by immigration, we've seen tons of RFEs related to this, whether or not the position qualifies for a specialty occupation. And there's 4 ways to show. One is that, is it common to the industry, as Lutka mentioned? And to show that is you would do just a quick search online to see whether or not this particular position requires a minimum of a bachelor's in a specific field. The second one is are the nature of the job duties complex, technical? And a way to show that is to take a look at the job description and compare it to the academic transcript and say, look, in order to perform these tasks and duties, one must, be proficient in these courses. Okay, so that's the second way. The third way is that, is it common? Does the employer typically require a bachelor's degree in this occupation? And we show that through organizational charts, through payroll documents to show that they have other employees, either currently or in the past, that that had similar degrees. And then the last criteria is, is it common? According to the Department of Labor, they're going to look at their resources and they're going to see whether a bachelor's in a specific area is normally what's required to enter the occupation. So again, these are 4 ways to meet the specialty occupation definition. And most importantly, you only need to meet one. Okay, there is no requirement that you show that you meet all 4 criteria. So that's also important to note.
So just a couple of points. One is that everyone should know that the issue of specialty occupation was going to be modified by the Trump administration, and that was taken offline, thank goodness, because that was going to be a much more rigid interpretation. So that's number one. Number two, with regard to specialty occupation, one of the other things that employers can think about doing if they haven't already done it, and that would be pre-March registration, is to run an advertisement and ask for a bachelor's degree for the particular position that they might be thinking about doing the H-1B for, because then you're creating, if you will, a paper trail that when you recruit for this particular position, you ask for a bachelor's degree. Or what you could do is go into other job listings and show that bachelor's degrees were required for that particular job function. And these are things that you can get in place. And the reason why you want to do this is because you want to start thinking even early on about the potential for a request for evidence. And this is what you would use to potentially overcome an argument by the government on a request for evidence.
But it's not required. We get that question. It's
correct.
totally not required. So that's just if you want to do. So David, tell us about the H-1B lottery process. We had some changes last year.
We did. We had some dramatic changes last year. And I think that the interesting thing is going to be what potential dramatic changes do we have that are forthcoming this year? And I know that everyone probably on this webinar is dying to know, because I think that the 3 of us are dying to know. So we are standing ready, awaiting guidance from the government, because there was some discussion about the fact that they're going to be changing the lottery process. I'm going to talk about last year's lottery process, but before I do that, I just want to give everyone sort of an idea about what we're waiting for, because I have been receiving questions, I would say, every hour from folks asking about the new methodology. And the new methodology that they're thinking about rolling out has to do with choosing the H-1Bs based upon the higher wages. So level 4s will be chosen, level 3s will be chosen, level 2, level 1. So what essentially is going to happen potentially is that there may be very few H-1Bs available when they get down to the level 1 lottery. So essentially what the lottery is going to be is that they're going to be conducting 4 separate lotteries. One lottery on all the level 4s, then all the level 3s, and all the level 2s, and then all the level 1s. So unfortunately, there may not be a whole lot of H-1Bs available for level 1s if this lottery concept goes through. Now, legally, it probably is. It's unlikely that it's going to become, the reality. But we are monitoring this very closely, and we are going to be providing cutting-edge information to anyone who's on this webinar, and out there who wants to know. So
within 2 weeks, we should know for sure,
Exactly.
because government needs to make announcement by February 16th. So happy waiting.
Exactly. So what happened last year was that we went from where we were preparing the full H-1B and submitting the full package to the USCIS. And the USCIS got about, 250,000 packages in one day on April 1st. They decided to change things a little bit and to modify the process to be a online lottery process where on March 1st, employers would work with the hopefully their lawyers or with the beneficiaries. And what they would do is submit registrations for the CAP cases. And then what would happen is they would run a lottery around March 20th, choose the winners, and then those winners would be able to apply or to petition for the H-1Bs starting on April 1st for an October 1st start date. And that's super important, for everyone to understand, is that we're talking about something in the future. We're talking about a prospective position in the future. And why is that important? It's because a lot of times when you approach your employers, and I would say 9 times out of 10, I get the question, do we have to increase the wage now? Do we have to, because obviously if you have someone who's, let's say, in OPT and then the H-1B wage is higher, do you have to do it now? The answer is no. You're looking out to October 1st, okay? And that's when the wage kicks in, when the H-1B kicks in. So that's,
yeah, it was much nicer because we didn't have the stress of April 1st as it was for many, many years where we had to file all H-1Bs on April 1st. Now we had from April 1st until end of June to file all selected H-1Bs. So we basically had 90 days. So I think it was much easier for clients, for us, for employers. I think overall it went pretty well. Of course, there were some glitches, but I would say all in all, it went well.
And I think that also I just want to mention that, and Snehal, I think at the end of August, we had another opportunity and a second bite at the apple. Can you tell us a little bit about that second bite at the apple and whether you think maybe we might see that second bite again this year?
Sure, absolutely. So once they finished the first lottery selection, of course, this was right as the COVID pandemic hit. So unfortunately, many employers were unable to offer H-1B employment to those beneficiaries that were selected. So some of them were not able to file the actual application. So what that meant was it opened up, it made more visa numbers available. So what the Immigration Service did is they went back into the registration. They didn't open up the registration to allow new registrations. They just went back into that same applicant pool and selected a second round of beneficiaries. And so that happened in August. And in terms of this year, if they do run the lottery, starting in March, it's probably likely that they will have a second round, considering, we're still in COVID and there seems to be a lot of misinformation and confusion about the wage-based selection process. So who knows if employers are actually going to go in. So I think it's reasonable to anticipate a second round of selection for this year as well. I mean that we don't have a crystal ball, but that's what we're thinking.
Great. So obviously now, coming out of or riding the wave out of last year's registration, there are a couple of things that we learned that we're going to be sort of more mindful of. Last year, the registration process was unprecedented. So what are some of the things that we learned, Ludka?
Well, it's important to start early on, just to plan. And it's not even about the registration because, I've heard afterwards from employers, oh, we did the registrations and, we got selected. And then I look at offered position and it was not professional or specialty. So I would think it's important to start with, once your employer decides that they want to do H-1B for certain individuals, I think it's important to just determine whether this is H-1B material, whether it's professional specialty occupation. So that's number one. It's important to start with the account creation early on as well, because we've seen a lot of issues. There were some employers that just did it themselves, some where we assisted. And I just saw that there were some issues, they didn't get the email and so on. So I think it's important to start early on. And if there are any technical issues, so we have time to resolve it. I think that's number one. Number two, multiple registration problems. So what I have seen personally was, disconnect between the client, employer, and us, for example, where we were supposed to submit the registration, and what happened was both employer and we submitted the registration. So it's very important to be clear with the employer who is doing what, because that's a big problem with the multiple registration problems. And of course, the company may be too eager to file registration, and they may have other subsidiaries, and they may be thinking of doing registration with those other companies. So, they have to be careful about that, because obviously there is no multiple, that could be a huge issue. So, but I've seen it only with employers that try to do it themselves, that they didn't realize that they cannot do that. So I think multiple registration, that's probably the biggest issue with the
One other thing
registration.
I'd like to add to this is that there was talks last year that if once the employer was selected and if they did not file, that the U.S. Immigration Service was going to follow up to find out why you didn't, in fact, file for this individual. I think that was also, in an effort to curb fraud, with the H-1B program. But we actually did not end up seeing that, and I think a lot of that also has to do with COVID. Many employers were laying people off, shutting down, so they just were not able to file. So we don't know if that's going to happen this year. After the fact, the Immigration Service following up with the petitioner, which would be the employer, to find out whether or not they did in fact file or why not.
So I just want to point out with regard to multiple registrations that individuals can do multiple registrations with different companies. That's permissible. That's not a problem. Where you run into potential issues is when the companies are determined to be alter egos of each other by virtue of potential shareholdings that are, and it's incredible how rigid the interpretation of the government on that multiple registration analysis is, because even if it's a minority shareholding, they're still considering a minority shareholding to be sufficient to be able to say that those are considered to be multiple registrations, which could potentially result in the nixing completely of your H-1B lottery entry. So, notification timing. What issues do we see with timing? So with regard to timing, we have to be mindful of our students who I think are dealing with potential cap gap issues, where they're going to have to apply for the H-1B before they run out of employment authorization. If they don't make the application prior to their running out of work authorization, then what would end up happening is they wouldn't be able to continue to work until October 1st. So cap gap is very important. I think that it's really important for both the employers who are on and the potential H-1B beneficiaries to know that during the cap gap, you have to go back to your international student office and get a new I-20. It's a new cap gap I-20, which enables the employer to be able to properly do the I-9 form. So, so stay in close touch with your international student offices. If they have not already explained that to you, that's definitely something that you want to be mindful of. Premium processing. What happened last year with premium processing, ladies?
We had premium processing. I'm trying to think when We had it a little bit later on. That was actually phased premium processing for those, I think, where there was a change of status. Then later it was canceled processing. So we ended up with premium processing, which was great. But I have to say that those cases that were not premium processed, we were getting decisions very quickly in a matter of weeks, which was very surprising because we were expecting major delays because of the pandemic, of course. So I don't know about the two of you, but if all my cases that were regular were actually approved very quickly.
And so, yeah, go ahead.
We're actually still seeing that. Even cases that are being filed now are not taking as long as they typically would take. So premium processing many times during the H-1B cap season is taken offline because it's just an insurmountable task, I think, for the government to try to get through the sheer volume of cases that are filed within a 15-day turnaround period. So generally, during the H-1B cap season, they take premium processing offline initially and then resume that. So we're not sure exactly what will happen this year. And of course, as I'm sure a lot of our listeners know, premium processing has been increased to $2,500 now.
Yes. Thank you for pointing that out. And
substantial.
That's great. And also, I want to just quickly point out, because when we say premium processing, we just assume the whole world knows what we're talking about. Premium processing is the submission of an additional document. It's an application to have a decision in 2 weeks. So it's a 14-day turnaround time. And then the question I always get is that 14 business days or is that 14 calendar days? What is that? So the turnaround time is, it's supposed to be in 14 days. I think I've only had one premium processing check returned because the government said that they weren't able to do it on time. That happened once, but generally, if you need to get something turned around very quickly, that's the process. And so it's a special form that the government has that you submit with that processing fee that Snehal mentioned. Snehal mentioned the second lottery process, which was in August, and I think also gave us that look into the crystal ball. And I thank you for that. That's perfect. And so, ladies, I'm just curious to know, what do you think is going to happen with the lottery this year? Are we going to have more H-1Bs, less H-1Bs, or the same number of H-1Bs that we had last year? What's your take on it?
I think it could be more or the same, because I think all of those students with the OPT, everyone is nervous, and they're going to try to do, or employers will probably try to do the first year of the OPT. So I think everyone is kind of stressed out about the whole immigration situation. So it may be the same or even more. Unless we see that the employers are less likely to sponsor. I don't see it right now. I still, even though there have been a lot of layoffs, but I see a lot of inquiries about H-1Bs. So, who knows?
Snehal?
That we can anticipate an uptick for the reasons that Lutka mentioned, but also we're seeing the tides turning with Biden. And so there's a lot of hope that there's going to be, major comprehensive reform. So I think, and, they are interested in keeping our international students in the US. And so I do feel that if they don't remain the same, they might increase, because there is hope that there will be major reform to get a lot of these foreign nationals who are in the US and working, maybe a faster track to getting that green card. So it might be a bit optimistic, but I like to be optimistic.
Yeah, I actually, I have another optimistic view, and, again, looking into the crystal ball and taking us off the immigration platform for a moment. We have a lot of folks from the IT area. I've been monitoring very closely the PPP program. And for those of you who might be aware of what's going on, is that the PPP program now is opened up and allows employers to spend those PPP funds on information technology improvements in their businesses. So I have a feeling that the PPP program is going to be a tremendous, tremendous boom for the IT in the next 6 months. And so I think for those employers that are keeping an eye, especially our, our smaller, mid-sized IT companies, if they have an eye on what's going on in the industry, I think that they're going to realize that they're going to have a big potential need within the 6 months for people to go out and start, helping other businesses to do this remote work and security work. So I think that I agree with you. I think that that's probably what's going to cause the uptick. My humble opinion, but. Okay, with that being said, what are some of the regulatory changes that are on the horizon? What's happening?
Well, I'm just going to jump into Baja because it's kind of funny to me that we've been talking,
Okay.
David, about Baja, Buy American, Hire American,
Right.
for the past 4 years. We did countless of presentations, explaining what Baja is and what happened. And here we are. There is a new executive order. I think this was on January 25th, maybe, or 21st. Ensuring the future is made in all of America by all America's workers, and that revokes Baja. So here we are, 4 years later. So that's just something that jumps at me. That it's a huge. When you mention changes, like this is a huge change, because we've been discussing this for the past 4 years, and now it's out of the window, which is definitely positive.
Yeah, and it signals a 180-degree change in philosophical, in change in immigration philosophy. So that's, again, going to what Snehal was saying about being optimistic. This is definitely a signal for us to be optimistic. So if we're going to do some bottom-up processing here, how about the status of the travel bans? What's going on with the travel bans?
So the COVID travel ban against Schengen countries and Brazil and now China and Iran, it's still there. I know there was a lot of confusion because I think on January 21st, President Trump took it offline, but then it was reinstated. So we still have that. The COVID-related travel bans, we still have it. And we have the rest of the travel bans as well until end of the March. And, we'll see if it's going to be extended. So everything is still in place.
There's also
they recently added
the additional,
I'm sorry.
Right. There's also the additional policy or executive order that international travelers coming to the U.S., they have to show that they've tested negative for COVID-19 3 days prior to their travel. So
that's for U.S. citizens as well. That's for everyone.
Right. All international travelers. Right. And then we have the non-immigrant visa ban and the immigrant visa bans that, as Luca mentioned, that were due to expire, were extended until March 31st by Trump. Again, these were his midnight rules. And so we're hoping that the Biden administration is going to rescind those, but he might just let them lapse, and that would be unfortunate. But it looks like that might be where we're heading.
But David, what did it create? We often talk about it. What did it create? Because that was supposed to end the immigration. So what happened here in October? With the adjustment of status, all these bans.
Oh, yeah. So thank you. I'm sorry. I'm thinking. I'm actually so bans. I was going to ask a question of both of you, so don't let me forget it. And that is, bans to me sound so scary that like everything is banned. And I think everybody got really scared when that ban went into place back in April of 2020. Like all of a sudden everyone goes, okay, it's banned. But I know that we have workarounds called national interest exemptions. So we're going to talk a little bit about that because I think it's important for our viewers to know what that is and how it works, especially the HR, because, where they think that something is completely banned and they can't get around it, we don't want them to go away with that thought. But so what's really interesting, and thank you for raising it, Ludka, is the complete irony of what happened last year was that President Trump announced a ban in, I think it was April, and he put this immigration ban in place. But the problem was he didn't realize that what was going to end up happening is no one could go and pick up green cards at the US consulate offices. So then what ends up happening is that when October 1st rolls around, all of those visas that were not taken up at the US consulates abroad got dumped into a big pool, and they were made available for people to adjust their status. So in October and November, I think not just the three of us, but I think our whole staff, no one slept for about 60 days because we were getting hundreds of adjustment of status applications out the door for people who had been waiting for years and years. So what, the irony is that ban ended up turning into an acceleration of priority dates. So
those employees that are in the US, all the people that are in the US were actually super happy because they were finally able to file adjustment of status. So it was an irony.
Exactly. So I'm just going to go to the next, again, working our way up. So the Biden administration canceled, and I think I had mentioned this before, the restriction or the more rigid interpretation of what is considered to be a specialty occupation. And then there was some discussion with regard to the possibility that end users of H-1Bs were going to have to do LCAs. So what would end up happening is if you had, let's say, an IT company hired an employee, put that person on an H-1B at, let's say, a pharmaceutical company or off-site, then the pharmaceutical company, the ultimate end user, would have to do an LCA. So that was also taken offline. That would have been really interesting because that modifies completely the relationship or the definition of employer-employee. So thank goodness that's offline. Let's talk about, just quickly, I think we already pointed out this wage-based H-1B selection rule. Again, we're waiting to see what's going to happen. What I think worries me a little bit is that I read something last night that they had actually modified the lottery entry documents, and they've also modified some of the other documents to reflect the wages. So it could be that they're getting ready. Yeah, so it could be, and maybe can you guys elaborate on that a little bit? Because I just read it very briefly. Are you familiar with?
Well, they've started to do that, right? The registration part and also the forms in terms of the wage levels, whether it's a level 4 wage, 3 wage, and so on and so forth. But again, we're not exactly sure what's going to happen. We're hearing that in the immigration attorneys community that most likely it's not going to happen this cap season, but it's a day-by-day approach, and we'll see what happens. And if it does, in fact, take effect, I do think it's going to be challenged, like so many of President Trump's immigration policies, that they're very quick to put these policies in place, and then they get challenged, they get taken offline. And so I think that we can anticipate that if it does go into effect, that it will be challenged. I think that there are interest groups ready to file a stay order or something.
I agree. And I think that also what it does is it signals for us as immigration law professionals, it's a major red flag for us to work very closely with our employer clients now to analyze this, the potential H-1B and the wage, and to really kind of come up with a strategy now. So there's really, so it's almost like now there's even more of a need to do strategic planning with our clients in advance of this this H-1B lottery. The new Department of Labor prevailing wage rule was announced. It actually ended up, so far it's in effect as far as we know. The actual changes in the wages will not occur until July 1st. So, they're talking about basically in terms of, I guess a quick and dirty way to understand it is that level 1 wages, level 4 wages are going to be going up. Level 1 wages will become level 2 wages, level 2 wages will become level 3 wages, and level 3 will become level 4. So the wages purportedly are going up. There were some statistical issues with the original Department of Labor wage platform that was introduced, and then they sort of recoiled, took a step back, and re-proposed. So we'll see really what happens with it. But again, to me, it signals that we have to work very closely with our employers to make sure that there's a strategic plan moving forward. Because these wages are going to be changing effective July 1st, we, I think, want to be working very closely with the employers to talk about the possibility of locking in wages under the OES prior to July 1st, which would be doing new LCAs. So that's something that we will have discussions, with our H-1B wannabe employers as we proceed. We'll go to
So
the next
there was a
slide.
question,
Oh,
it just disappeared, but I saw a question. What is your gut feeling about that registration based on the wage? So I'm just going to answer, and then you guys can say, I don't think it's going to happen. There's no way, because with the, postponing the 60 days, I don't think it will happen. That's just my gut feeling. How about you guys?
Yeah, I think that's what we said, is that it's unlikely that it's going to happen this year. And again, if it does, I think that we should be prepared for litigation.
Yeah, and I think that the viability of this type of a proposal really inheres in the definition of the H-1B process, and that is that H-1Bs are to be randomly selected, and that artificial criteria such as individuals' backgrounds or wages should not be the driving force behind the choice of how the H-1Bs are supposed to be chosen. So I think I agree with both of you that most likely, if something like this does come into play, it will be challenged, and it's likely that a restraining order will be implemented. And then of course we'll have to see how a court ultimately feels about it. But my humble opinion.
So these are just dates that we discussed. Hopefully, as it was last year, it would be March 1st to March 20th for the registration. Remember that the filing date starts on April 1st. Start date of the H-1B is October 1st. And, we just have
when
a
the wage
note.
becomes effective. Yeah.
Yeah, it's important that if you have someone, for example, you may have an employee who holds J1 or I don't know, E2 or some other visa category that is not F1, and the actual status expires before October. Even though you file on April 1st, you may have an issue, you will have a gap, so you will have to deal with it. So as David mentioned before, H-1B is October 1st start date. So you need to ensure there is no gap in status. With the F1, it's simple, but with other visa categories, you need to ensure that there is a legal status up until October 1st.
That's also assuming that they're going to remain in the U.S. to do a change of status. So, there is also the option of, if your status does expire prior to September 30th, that you file for consular processing if you don't have anything to fill that gap. So then you would file for your H-1B visa as consular processing and process the visa outside the U.S. Now, in that particular case, the wage level would only become effective when the employee actually travels to the U.S. on that H-1B. So that may or may not be October 1st. It might be sometime after that. But when they are then in the U.S. on an H-1B is when the new wage would kick in.
I'm just going to take this one question because I think this one is important. About someone is saying that they filed STEM OPT, they don't have a receipt notice. What do I do? So it's very common. I see it very often. So there is a major, major delay with issuance of the receipt notices. So I hear it not just from the STEM OPT applicants, but from anyone. Just to give you an idea, from October rush that we had with adjustment of status, we still don't have the receipt notices, and we are in February. So even with the STEM OPT, I hear from students that there are a lot of delays and they still don't have the receipt notice. What I would want to warn you is just make sure that when you filed it, there was a proper fee, that the form was signed, there was a correct addition of the form, because if you now discover that there was a wrong fee or wrong form, or you send it to the wrong service center, then it's going to be rejected. So you may need to refile it. So you may want to check if maybe your check was cashed. But, just FYI, there are a lot of delays with issuance of the receipt notice. So it's quite normal.
Great. We'll go to the next slide.
Hold on.
And
So
I think it's important also, do we have a slide on the number of H-1Bs? Because we have batch, okay, that'll be the next one. Okay, so generally, for those of you who are maybe aware, the H-1B is good for 6 years. It's a 3-year initial grant with a 3-year extension. Any time spent outside the United States, of course, can be recaptured. That's any time, vacation time, any time outside the United States. And obviously, if you have an approved I-140, then in some cases, you're going to be able to get 3-year extensions beyond the 6 years. And that's really important to our Indian and Chinese clients, because they're going to be battling extremely long priority date backlogs in the visa bulletin. So we use AC-21 to try to get them those extensions beyond the 6 years.
And David, when can you start the green card process? Because we get this question very often. Once the individual has the H-1B, is there any time limit where they have to wait? When can they start the green card process, whether it's a self-petition or employer? And employers, they like to ask that as well.
It's a great question. And actually, I was on the phone with a client yesterday who was eager, actually their employer was eager to start the perm labor certification process even before the individual had their H-1B. So although I can definitely answer that question, I'm going to punt it over to Snehal and let her answer that question. So Snehal,
sorry, I'm just
when can, no worries at all. My question for you to answer is, when can you start the green card process?
Oh, when to start the green card? Yes, we actually have a question. As soon as possible, because we want to secure that priority date, especially as we have all mentioned, if you are from China or India, you want to get started as quickly as possible, because that priority date is going to determine when you will be able to apply for an adjustment of status. So while you might have a total of 6 years, you want to start as early as possible in the process. And that also is because for most people, they're going to be filing the green card on the basis of a perm application, the labor certification. And that process, also takes time. And there's no guarantee that the perm will be eventually successful. So if you start early in the process, in the 6-year period, you have the most flexibility and the most options to be able to refile if you need to. But at the latest, you must start by year 5 of your H-1B in order to get that 1-year extension on the H-1B. Once you secure that I-140 approval, you can continue to extend the H-1B in 3-year increments until your priority date is current and you're able to file for an adjustment of status. So we have a lot of clients that, who may be from China or India, that have been waiting for a really long time to file for an adjustment of status. And they started that perm process, 8, 9, 10 years ago. So that's really what you want to do so that you're able to continue to live and work in the US under the H-1B.
So Ludka, I had a gentleman who called me yesterday and he said that his employer was so excited to get him started, and they wanted to start the labor certification even before he had the H-1B. What would you recommend?
So if I know, you mean, for example, that the H-1B was already approved and it's supposed to start on October 1st, or they're just doing?
They're just doing.
They're just doing.
Yeah.
Well, it depends. It depends where this foreign national, what country he was born in. So if it's Indian national, that's different because of the priority dates that being backlogged. So it's hard to say. You could proceed eventually, but as I explained, it's not ideal. It's better just to get the H-1B first, because you don't know what you want to do in the future. So if the person has F1 OPT, and it's just 1 year, it's probably not the best idea, because let's say they will continue the F1, they need to go back home to the consulate to extend the F1. If the consulate will see that they have immigrant petition pending, it's going to be a red flag. So it depends on many different factors. You know, again, what country they're from, how much time they have. Preferably, you don't want to start the green card.
Right. So it's a
But
totality of
There are
circumstances.
exceptions. You know, if it's somebody, you know, it's a 3-year OPT, STEM OPT, and it's not India or China, you know, maybe, you know, many people, as we discussed, do national interest waivers. So it's hard. There is no black or white answer or response. It just depends on the circumstances.
So one thing I just want to add to that is that the green card application for most people, again, is the starting of the PERM process, is prospective employment. So you don't actually have to be working for that employer for the employer to sponsor you for the green card. So many times we have, or it could be in a different position as well. So if you have an individual that is working for company A and maybe gets an offer from company B for sponsorship, they can do that. So there is no requirement that the employer starting the PERM process for you, that you actually be employed with them. So before they start working on an H-1B, if they are in another category, it's possible to start the green card application, of course, assuming that you have a dual intent visa and that the timing you know, works out. But generally you do, most people are in the H-1B category or status, and then they do the PERM labor certification green card process. That's the typical path.
So on the next slide, Ludka, thank you for putting it up. I think that it's important to point out to everyone that H-1Bs are employer specific. The employer drives the process. One of the things that's very important is that concurrent H-1Bs are permitted, and also part-time H-1Bs. I think we did quite a number of part-time H-1Bs last year. And, you know,
is the chance better if they are full-time?
Doesn't make a difference.
Exactly.
We have found that part-time H-1Bs are as effective as regular H-1Bs. And H-1Bs are also portable, and the portability provision in AC 21 section 105 allows individuals to move their H-1Bs once they have the H-1B, which becomes activated on October 1st. They can move that H-1B to a new place of employment. So that's a tremendous value to winning the lottery, let's say with one employer, and then all of a sudden after you're working for that employer for, let's say, a short time, all of a sudden you get a flurry of offers from other employers who see your value. You can move that H-1B to one of those other employers if you're so inclined.
I just want to clarify that employees or applicants cannot do H-1B registration themselves. So it needs to be the employer, and employer is also filing the H-1B. It's not the applicant is filing the H-1B.
Right, and I think it's also important to point out, because I don't think we have a slide here, is that the employer's obligations with regard to the H-1B is that they do an LCA, a labor condition application, and then that labor condition application is a physical posting or an electronic posting, and then they also have to do what's called a public access file and maintain that public access file for the employee on the premises in the event that anyone has any questions about any of the details underlying that H-1B petition.
David, what do you, or Snehal, what do you guys think? Can employers, I got that question yesterday, can employers file H-1Bs themselves? So let's assume they've never done it.
Whew, that would be brave.
Well, first of all, I think that, you know, all of the resources are available on USCIS.gov, the forms. However, this is a very complex process. And the first part of it is the registration. Can an employer do that on their own? Possibly, sure. Then they retain an attorney to complete the H-1B process. I mean, we handled a lot of those cases last year. But if you've never filed an H-1B before, you know, we would not recommend you do that, because the last thing you want is to be selected in the lottery, file your case only to find out that it was rejected because you missed a form application requirement. And then you might not be able to continue to employ that foreign national. So
there are many nuances. So maybe
yes.
10 years ago, right now, David mentioned PAF. So that's something that we also prepare for the employer. So there are many different obligations, nuances that even though, yes, you have resources available on the USCIS website, but I would not recommend to proceed with the H-1B on their own unless, they have immigration counsel and they do it on their own. So, that's just question I got yesterday.
Yeah, so I'm an immigration. I'm a lawyer, and when I buy or sell a house, I hire a real estate attorney to handle the transaction because there are nuances associated with those types of deals. It's sort of the same thing. Is that I don't think that you want to be doing the H-1B. There are a lot of procedures in the immigration arena that can be done, by people on their own. I would not personally feel comfortable telling someone they can handle an H-1B on their own.
David or Sneha, what is the cost? Because we got a lot of questions about cost and who is responsible for legal fees and filing fees. So what if employer is willing to sponsor, but they don't want to pay the some of the fees? Can you guys tell us a little bit about that?
Well, under the regulations, I believe it's the acquia fee that has to be paid by the H-1B employer. We generally say, as immigration attorneys for the application, we're going to be representing both the employer and the employee. It is a dual representation type of case. In terms of our fees, we do prefer the employer to pay, but the employee can pay the legal fees. It's not a problem. The filing fees, as I said, the acquia fee should be paid by the employer. As long as, and if the employer has some type of agreement with the beneficiary, it's not been an issue unless that brings down the prevailing wage amount. If the employer is going to recoup these costs from the employee by bringing down their wages, that's not permitted. But if there is a separate agreement, that's generally not an issue for the purposes of an H-1B.
Yeah, and so the acquia fee that the acquia fee that Snehal is mentioning is what we refer to as the Department of Labor training fee. And the Department of Labor essentially in 1991 set up a fee whereby what they were going to do is use those fees to train US workers to do STEM associated jobs, to buy computers and Head Start programs and so on. So essentially those funds get put into a pool of money that the Department of Labor makes available to not-for-profit NGOs on an annual basis, where they can get that money to train US workers to do STEM jobs. So that's what that's for. Okay.
Mm-hmm.
Okay.
Okay, so the next slide just shows you how many H-1Bs. So we do have 65,000 H-1Bs annually, and then additional 20,000 for US master's level or higher. So those with a US master's level or PhDs that have definitely better chance as it is now. And here you have numbers. What was received last year. So there were a lot of applicants or registrations received.
So Lutka, one of the big questions I always get is, what are my chances to win the lottery?
So for US master's level, it's pretty high. I mean, you are the better in statistics, David. You always explain
Well, yeah. So I think that in the master's level, you're talking about 1 and 1.3. So 1 to 1.3 in the master's and 3 to 1 in the bachelor's. So for every one place that's available in the bachelor's cap, you have 3 applications generally. And with the master's, you have 1.3 applications for each master's place. So, I always get questions from, from potential H-1B beneficiaries who say, do you think it's better to get the master's degree and to go into the lottery with the master's degree? I think if you're looking for a better shot at winning the lottery, that's a definite for sure.
So what if you have an employer that is CAP exempt? You know, somebody comes to you and they'll tell you they're going to be working for the university, they have offer of employment, or they may be working for nonprofit organization and they are trying to do a CAP H-1B, specifically, for example, nonprofit organization. What is the first thing that you would think about? Snehal?
Well, those would be CAP exempt cases. So if you're going to be working for possibly the government, nonprofit, or or governmental research organization, they are not subject to the CAP. So they can file an H-1B at any time. So you wouldn't have to wait to go into the registration to be selected. That employer is able to file an H-1B for you as long as they're going to offer you, you know, the appropriate salary. It is a specialty occupation. They're not subject to the H-1B cap. And also, if you're filing, if you already have an H-1B visa and you're filing to do an extension, amendment, or a transfer, those are also not subject to the cap. So you don't have to go back into the lottery, and that could be filed at any time. And that should actually be filed as soon as there is a change, whether it's an amendment because there's a change in location, or a position, different employer. So those obviously will have to be done in real time as they happen. And
so that's something that we explore before, you know, if somebody comes to us and we see that it's a school or it's a nonprofit organization, that's probably first thing that we would explore. Is this a CAP exempt H-1B? Because then we don't have to worry about deadlines. We can file at any time. And many organizations don't know that they are CAP exempt. So it's really important to explore that. You know, oftentimes we have students or applicants saying, I'm going to be working for the nonprofit organization, but they don't know, we don't know. So, you know, unless they filed the H-1B before, they probably don't know. So it's important to explore it.
And it's part of the initial analysis to figure out, you know, whether they use a cap exempt H-1B as a backup position or whether they try it first before the, you know, before the lottery. So that would be part of our discussion with the employer.
So I'm gonna just jump, if you guys don't mind, into alternatives so we can then go over the questions. So, you know, obviously it's important to plan alternatives because it's a lottery. So if you're not gonna make it, it may be too late after the fact. So it's important to know what the options are. And also, Snehal and David, and I'm sure you've had cases like that, somebody comes to you with the potential H-1B, the HR may give you a resume, you're going to look at the resume of the individual and you're going to be like, wow, what a credentials. You know, this person qualifies for O1. So maybe you don't even want to go with the H-1B. So I think that initial consultation or analysis is super important because you may have other options. So let's go into that right away.
Perfect. So one of the backup plans that we always like to discuss with H-1B potential beneficiaries is the possibility that they may come from a treaty country. So there are treaty countries that, so first of all, there are E-1s. If you work for a company from that country that's involved in substantial trade between the United States and that foreign country, that could be an E-1. Or if you make an investment into your own company, so you essentially can create your own company, make an investment, a substantial investment into that company, and you can get an E2 visa and become an employee of your own company, and then you can lease yourself out to work for another company. So the E2 is a nice, interesting way to sort of a workaround or a fallback position in the event that the H-1B doesn't work out for you. And it doesn't limit you in terms of potentially going into the H-1B lottery in the future if you need to do that. What about the L visas, Ludka?
So L1 is a great option, but you know, the only problem is that your applicant would have to work abroad for either affiliate or subsidiary or parent company or branch for 1 full year. So you need 2 companies, US company and then company abroad. And as I said, the individual in the past 3 years had to be working for 1 full year for the foreign organization. But it's a great option. There is no, for any of those visas, there is no cap or lottery or anything like that. You can file at any time. That's why we like them. Because the H-1B is the one where you need to make it in a lottery. There is a deadline. So that's why we like other options. And if there is a better option, then it's just better to go with it.
Tell us about the O visa, Snehal.
Yeah, so the O visa is another non-immigrant visa. One thing I just want to add on the E is that that's a not strict non-immigrant visa. So typically you're not going to do E and then green card. The L is great, it's dual intent like the H-1B. The O is also dual intent, so you can pursue a green card. So the O is for individuals who have, extraordinary ability, artists, people that are, the best of the best, but it's not the EB1 one that people think of when they're trying to apply for the green card. It's not as difficult, but nevertheless, you do have to show how you stand out. And if you are outstanding in terms of in science, technology, mathematics, or artists, graphic designers, that's O1B, that's also a possibility. So if you're within one of those occupations, the O should be explored for sure because there is no quota and there's premium processing available. So that's a great one. And then how about the P, David or Ludka?
Well, the P is a very interesting classification. P1s are for athletes. So we always try to inquire as to whether or not individuals are athletes. But I happen to be a fan of the P3, which is for individuals who are involved in cultural uniqueness. So anything that might be culturally unique in some way, there might be an opportunity for P3. So it has to be culturally unique and something that's being shared with the public as a whole. So for example, a lot of our international chefs, they would be P3. Individuals who are involved in something maybe that work, let's say some work for one of the international chambers of commerce, that might be a P3. So those are high, there's a lot of creativity that can go into the P3 visa. So we like that. How about the R, Ludka?
So our visa is for religious workers. So obviously ministers, that's an easy one, but also religious workers. So they don't have to be ministers. So if somebody has an offer from a church, temple to do religious work, for example, we've done music directors, Sunday school teachers, that's going to qualify for R1. It's a great option because R leads to a green card. So, at the end of the day, you can proceed with the I-360 and proceed with the green card.
Great. B1? Shall I talk a little bit about the B1? Yeah. The B1 is a non-immigrant, as actually Snehala pointed out before, it's a pure non-immigrant visa. It's not a huge duration. It's not a long time, but you can ask for a year. Oftentimes we'll use the B1 as a bridge to go to an E2 because there is a provision in the Foreign Affairs Manual that does allow for individuals who are seeking investment in the United States, to be able to get B1 status. So, also, I just want to quickly, as an aside, mention that there was there was a rule to try to eliminate the B1 in lieu of H-1B. Correct. And just to let you know, that was taken offline. So B1 in lieu of H-1B still lives. So that's good. How about the TN?
Go ahead, Snehal.
Okay, the TN is similar to an H-1B, but it is specifically for our Canadian and Mexican foreign nationals. And so the TN visa, the occupation must be on the list of NAFTA occupations. And if it is, then it's possible to travel to the US on the TN. And each occupation has very specific requirements, whether it's the bachelor's degree, work experience, a license. And so if the occupation is within that list of NAFTA specialties, then you're able to file for a TN. But again, it's only for Mexicans and Canadians, and it is also not a dual intent visa. So a lot of times our TN for our nationals, they come on the TN and then we try to get them on the H-1B so that we have the ability to go into a green card. And the TN can be also extended indefinitely. E3?
And the E3 is for all, it's basically an H-1B for Australians. You need to do an LCA, get the LCA approved, and the individual can get an E3 stamp, come to the United States as a Australian professional. Okay, and U visas are non-immigrant visas for, oh, sorry, go ahead, Luca.
Yeah,
Go,
your
do it.
favorite. So U visa, victims of a crime. So hopefully nothing happened to anyone, but you know, if it did, then it's worth it to look at it. It's a great path to a green card.
Exactly.
So we have about 10 minutes and I'm just going to jump into questions if you guys don't mind. So, you know, as a one of the questions here I see, can spouse of an H-1B, which is H-4 visa holder, work?
And the answer to that is they can under certain circumstances. And Ludka, right?
Yeah, it depends.
It depends, but
so,
you have to, yeah, go ahead, Ludka.
You need to, it's very important for the H-1B visa holder to start the green card process, have the I-140 petition approved, and with that approval, the H-4 spouse can apply for EAD, for the work permit. And, you know, for the past few years, there have been a lot of discussion to take it offline, but,
they never got there.
Yeah. We never got there, and now that's gone. So it, you know, it's still, it's mostly for our Indian clients, Chinese clients, those with a big retrogression, because obviously it may take 10, 15 years for them to get the green card. So meanwhile, the spouse on the H-4 can work.
And it's kind of interesting, actually, if you look at the reason, I'm sorry, the reason why it had such trouble, you know, getting eliminated is because all the other countries have, you know, it's really became an issue of reciprocity because all the other countries did allow spouses to work. And so that's why there was so much resistance to getting rid of it. I'm sorry, Snehal, go ahead. I'm sorry.
One other thing is that, you know, if you are on an H-4 and you know, the H-4 visa holder has academic credentials, that individual should also consider going into the lottery, you know, for the H-1B, because if they have an offer of an employment, why not? Why not be on your own H-1B? That's also something to consider.
That's a great point. And actually, it also raises another point, and that is if you're L-1B, maybe you want to go into the H-1B lottery too, because if you're L-1B, you only have 5 years, whereas if you have the H-1B, you get 6+. And so for those folks who got L-1Bs who aren't converting those to L-1As and doing the green card, you may want to think about going into the H-1B lottery and grabbing an H-1B and extending it out until the priority dates become current.
So I'm going to take this next question. Can we file for H-1B after OPT? Then if rejected, probably if they don't make it in a lottery, can we do masters with STEM, stay with the same firm on CPT or OPT with the same firm? So absolutely. If you didn't make it in a lottery, I think that's one of the backup options that we didn't mention is just go back to school. That's typically, if you don't qualify for anything else, go back to school, do the masters, then you're going to get STEM OPT for 3 years, and hopefully you can make it in a lottery, you know, within those 3 years. So that's one of the alternatives as well. Just go back to school. David or Snehal, I have a question for you from Lindsay. Does buying a property as an Airbnb, B&B business count as a business for e-visa?
Well, just buying a property in and of itself may not be sufficient. One of the things that we have to show for the e-visa is that our national, the treaty investor in this case, the E2, is going to be developing the whatever the business it is, control the business, develop the business, hire employees, not necessarily a very large number, but in terms of overseeing. And also the individual, the E2 visa holder, cannot really be directly competing in the marketplace. That's also a key factor for these E2. So, if it's going to be more than one and you're going to have, a larger operation, potentially, it just needs to be structured a little bit creatively, I think, and it might work. David, did you want to add something?
Exactly. I think that's right on the money. I think that if it's really being used as a business, and Airbnbs generally are used by folks to generate income, then it should be fine. If it's not being used to generate income and it's being used as the individual's personal residence, then it's not deemed under the law to be a substantial investment, and therefore, it's what they refer to as marginal. And because it would be marginal, it wouldn't pass muster. I agree.
Okay. I've seen this question several times. For transferring the H-1B from one employer to the other after October 1st, what is the general rule to wait in order to, to file the transfer? Like, do you have
That's
to
a great
first?
question.
Yeah, there is no rule. There is no rule how long. You just have to assume the H-1B. My rule is that you need at least one pay stub because that's how you show that you assumed the H-1B. So I've had cases that after 2 weeks, the employee decided to transfer the H-1B. So that's possibility as well.
I think I think the answer there is whatever you can use to prove that you were on the payroll of the employer who sponsored the H-1B, then it works.
Okay, we answered all of these. For concurrent, okay, this is a great question. That was the first question. Remote working. And we had a lot of presentations regarding when starting in March. So obviously most of the people are working remotely. How does this affect H-1B? Can you do that? What needs to be done?
So one of the things that we've been doing is when we prepare the LCA, we always include, we try to work closely with the employer to find out what those remote sites are going to be. And then, of course, when we do the LCA, we have to make sure that we make those full disclosures. So that, I think, is the first and most important. Can you work remotely? I think the answer is absolutely, as long as if it's within the same MSA, then you just have to repost.
What is MSA?
I'm sorry. Right. Thank you. Mean statistical area. So usually that's commonly referred to as commuting distance, which I believe is about 55 miles or so. So if you're within 55 miles, you can take the old LCA and you can post it at the new site. And that usually gives you compliance. But if it's beyond the original MSA, then you're supposed to file an amendment with the new LCA.
So basically now for any new H-1Bs, what I think our rule is that we include person's home address because most likely they're going to be working from home. So going forward, this is our practice that we definitely include home address as a work site as well. And there haven't been any issues. I haven't seen any issues from the government.
So you have to post in 2 conspicuous locations on the premises. So folks have been posting on their front door and on the bathroom door, or in the kitchen, or on the refrigerator in the kitchen. So, yeah, exactly.
Yeah, I haven't heard of any home inspections.
Right.
No, this is just to ensure that the employer is in compliance and the information is, kept with the path.
Can the individual work on OPT from outside of the US, from the home country, and is there any limit? How long? I can take that question. Yes. So, if the employer will allow it and you can work remotely, in fact, many students were stuck in that situation that, for example, they left in February or March for vacation, and they actually couldn't get back. So they, continued working on OPT abroad, and there is no time limit. Okay, and I think we're pretty much done. We have 1 minute left. So any final words? Words of wisdom?
The only thing I think that everyone
Closely
is already,
monitoring the changes, whether or not the wage levels are going to be used to be the selection process for this year's lottery, what other changes we can anticipate. So stay tuned for that. And I think you should get your information, your cases, your employees ready for the upcoming lottery, because it will happen. We don't know when it'll start for sure, but that's what we can anticipate.
so I would just want to sort of mimic what President Biden said, and that is that there is a recognition about the value, the tremendous value that's brought to the United States by foreign nationals with regard to creating jobs for US workers. If you take a look at the CEOs and the folks who are running the companies in Silicon Valley,